Hi everyone, I'm Kelly Longtin from Kelly Longtin Law, and today I would like to talk to you about special needs beneficiaries and how they need to inherit and different ways in which they can and should inherit. Now, if you want to provide for a loved one who's disabled or has special needs when you're no longer here, care must be taken to ensure that the inheritance you leave will help rather than harm your loved one. An inheritance received outright could negatively impact your loved one if he or she is currently receiving government aid or benefits or will need to apply for the aid in the future. Government benefits for individuals with mental or physical disabilities, such as Supplemental Security Income, SSI, or Medicaid, are need-based. To receive these benefits, an individual must pass a means test to ensure that the individual does not have adequate money or property that could be used to pay for care, such as nursing home care costs, in-home care, medical equipment, therapy, or any other necessities for proper care and living expenses. Suppose an individual with a disability or special need has too many resources, including property or money or income. In that case, the individual will either be ineligible for government aid or may be subject to a penalty period during which the individual is required to spend down the money, own no property unless it's maybe co-owned by a spouse, and have little or no income in order to become eligible for the aid. So creating a special needs trust, often referred to as an SNT, or a supplemental needs trust, can help provide for a loved one who's disabled or has special needs while maintaining your loved one's current benefits or leaving open the option for the need-based governmental aid in the future, even if your loved one receives an inheritance. As long as the SNT meets certain legal criteria, the existence of the SNT and the amount of money and property inside it will not affect your loved one's means test. Now, there are two types of SNTs. A first-party SNT, also called a self-settled SNT or a D4A trust, and a third-party SNT. And we're going to talk a little bit about both of those. Authorized under federal law, a first-party SNT is created by a disabled individual, a trust maker, using funds received through an inheritance or a legal settlement. A first-party SNT can also be created by an individual who later becomes disabled and wants to qualify for government aid, who has an income or asset limitation, a means test. Now, there are two types of first-party SNTs, both requiring the trust maker to have the mental ability to create a trust, whether it's an individual or a pooled trust. Individual first-party special needs trust or supplemental needs trust are funded with the property that actually belongs to the disabled individual. The property in this trust must be used for the sole benefit of the disabled trust maker, meaning the trust maker is the only beneficiary of the trust. The trust maker must be under the age of 65 and meet the definition of disabled when the trust is created. Now, a pooled first-party SNT can be created by a disabled individual over the age of 65 in most states, but it may also be created by the parents or the grandparents or the guardian of the disabled individual. The individual must also state that at the disabled beneficiary's death, the remainder of the trust property, up to the amount paid by the government for government aid, such as Medicaid, on behalf of or to the disabled beneficiary, must be paid back to the government. This is often referred to as state recovery of the aid of the government paid to or on behalf of the disabled person. Any remaining amount can be paid to other beneficiaries that the disabled beneficiary named in this first-party SNT trust agreement. By contrast, a third-party trust can be created by any person wishing to give money or property to an individual who is or may become disabled and therefore needs to apply and qualify for governmental aid. A third-party SNT can be created through a revocable living trust or a will, although keep in mind if it's created through the will, then they'll have to go through the probate process in order to officially create this SNT trust. A third-party SNT may be a standalone separate trust, either revocable or irrevocable. The third-party SNT is often created by a disabled individual's parents, which makes it easier for other people such as grandparents or family members or others to name the trust as a beneficiary or to give property or money to the trust for the benefit of the disabled beneficiary. If you're the parent of a disabled individual, consider adding a third-party SNT to your estate plan and let your family members know that it exists. In lieu of cash or other direct gifts, people can use the trust to receive gifts or an inheritance, knowing that it will be set aside for their disabled loved one without hurting their loved one's current government aid or affecting their ability to qualify in the future. Any property or money in the third-party SNT will not be an accountable resource of the beneficiary for any means-tested government benefit programs. Now, the primary difference between a first-party and a third-party SNT is that a third-party SNT does not require the government to be the beneficiary after the disabled beneficiary dies. Rather, the trust maker remains in control and can name the ultimate beneficiary of any remaining trust property after the disabled individual's death. This makes a third-party SNT an ideal solution if providing for a disabled loved one is your priority, but you want to maintain some control over the remaining property and money. Both first-party and third-party SNTs must limit the payments made by the trustee to or on behalf of the disabled beneficiary, meaning that the trust property should only be used to supplement, not replace, what the disabled beneficiary is receiving in the form of government aid. Depending on the limits set forth by the government program, providing the benefits to this disabled beneficiary, there may be a limit on the amount that can be spent on personal items. Trustees must take great care when giving money to or spending money on the behalf of the disabled beneficiary to follow both the trust instructions as well as the laws and the rules of the government program providing the benefits to the disabled individual. This is to prevent the disabled individual from being disqualified or kicked off the aid program itself. If you'd like to provide for an individual who is disabled or has special needs at your death, it is important to do so in your estate plan. A properly drafted and funded SNT can ensure that your loved one maintains eligibility for potential government aid and also still has the funds to supplement the aid your loved one might receive. We can help discuss your options with you. Please call us today to schedule an in-person or a virtual appointment, and you can always email us at info@Kelly-Longtin-Law if you have any questions or you want to talk about any of this further. So thank you for joining me. I'm Kelly Longtin from Kelly Longtin Law.